So welcome everybody to day 2 of our workshop on dispute resolution in the digital economy. It's a great pleasure for me to be moderating day 2 of this workshop on dispute resolution in the digital economy, which we'll be referring to as DRDE. This is hosted by the UNCITRAL Secretariat along with the Japan Ministry of Justice, also with the support from JIDRC and our Regional Center for Asia and the Pacific. My name is Jae-Sung Lee. I currently function as the Secretary of UNCITRAL's Working Group 2 on dispute settlement, and I'm also responsible for reporting on this topic to the Commission this year. And this is why it's a big pleasure and a big burden for me to be listening to all of the speakers today. Yesterday, we had a wonderful discussion on a number of initiatives regarding technology disputes, online platforms, developments in the field of international mediation, and also responses by governments and arbitrary institutions to the COVID-19 pandemic. So we kind of set out the landscape of what's happening out there. But let me first pass over the floor to Takashi to tell us what his take was about international mediation.
Thank you, Jay. I'd be happy to do a short recap on yesterday's session on the use of technology and international mediation. We had the pleasure of inviting Mr. James Claston and also Ms. Kun Fan share their perspectives on remote mediation. From their presentations, the use of technology and mediation sounded very promising. According to James' presentation, it seemed that mediation's adaptation to the remote environment was happening very quickly, and that possible solutions to address issues, such as the difficulty for mediators to build rapport with the parties, were already being invented and becoming part of practice. It was mentioned that those solutions included, inter alia, mediators meeting with parties less formally in advance, and mediators recommending that participants stand occasionally based on a research that showed that people think better when they stand. Kun's presentation, which followed, highlighted that procedural justice or fairness was key in mediation. It was said that the factors which come into play in determining fairness was equal treatment, respect, neutrality, consistency, trustworthiness, and ethical rules. Speaking of some of the factors, it was mentioned that technical imbalance was one of the fundamental issues that needed to be addressed in a remote setting. It was also mentioned that to maintain neutrality, caution was needed in holding private sessions. Her presentation underscored the significant role that mediation could play in the delivery of justice. So that was my key takeaway from yesterday's discussion on international mediation. And back to you, Jay.
Thank you, Takashi. I think you've highlighted a recurring theme of yesterday's discussions was, I think, threefold. First, the landscape of dispute resolution is changing, and COVID-19 has just put the fuel on that change. So we're seeing a number of changes being implemented. Second, there are increasing calls for enhancing efficiency of dispute resolutions, which has been there for a long time. But parties' expectations are also changing, and one way to respond to those expectations is that use of technological means. The third takeaway was that there was there was emphasis that the underlying principle of dispute resolutions, which I see as a party autonomy and due process, has to be preserved in despite of these changes. And there were continuous call for balancing the efficiency on the one hand and the due process on the other, which is actually what we're going to be discussing today. But this is nothing new. I mean, it's been that the UNCITRAL arbitration rules, when it was revised in 2010, and a number of the arbitration institutions highlight the need for the tribunals to provide a fair and efficient process for resolving the disputes. So today we're trying to see if there is a need to actually change some of that. Now, the first panel today will examine how the use of technology has impacted arbitration in recent years, mainly to enhance its efficiency in dispute resolution. The second panel will assess the concerns expressed about the recent developments having a negative impact on the fairness or the due process, but also will highlight that some of the technological improvements are addressed to address those concerns. So we'll take a look at that. In a sense, we'll be doing a stock take of what's going on in international arbitration today. This was exactly what was proposed by Japan at the Commission last year. But that's not all. We're not taking stock for stock-taking purposes only. I should remind everyone that UNCITRAL is a rule-making body, an intergovernmental body composed of states and observer organizations, and to formulate harmonized rules for use in international trade. So this is where we need to actually focus on. Now, UNCITRAL has created the legal framework for international arbitration, starting with the New York Convention, the arbitration rules, and the model law on arbitration. Now, it will be adding the expedited arbitration rules to that plate. It is also expected to provide a similar comprehensive framework for international mediation, as the Commission this year is expected to adopt the updated rules on mediation, the notes on mediation, which will build on the work done in 2018 with the Singapore Convention on Mediation and the update of the model law on mediation. And some of you may not know, but UNCITRAL has prepared the technical notes on ODR, which was the topic of yesterday's session. So the underlying question that we have, or the Secretariat has, is whether these recent developments that we'll be looking at today call for action by the Commission to prepare something new, some sort of a legal instrument. And it is for that purpose that we are doing the stock taking. And we should be mindful of that. The purpose of the stock taking is to actually feed back into the Commission. And in so doing, we are relying heavily on our experts, considering that rather small team in the UNCITRAL Secretariat, to keep abreast of all the new developments. We have a wonderful lineup of speakers today who will share with us their insights in the 6 minutes allocated to them. I'm really sorry that we can only give you 6 minutes, but we hope that you can share your insights with us. So let's start with Andres. Can you tell us a little bit about what the working group was able to achieve last week?
Good morning, good afternoon, and good evening to everyone. Thank you very much, Jay. And of course, many thanks to the Ministry of Justice of Japan, JIDRC, and of course, UNCITRAL. My topic, as Jay just said, is to give you an update on the achievement of Working Group 2 on expedited arbitration rules. It is with satisfaction that I can report that during its session last week, the Working Group 2 completed its work on the expedited arbitration rules, which will be presented for the adoption by the Commission during the next summer or winter, depending on which part of the world you are. Considering the topic of this event, I will focus on the specific aspects in which the expedited arbitration rules relate to dispute resolution and the digital economy. As we heard yesterday from Cedric, a quick resolution of a dispute is key in many aspects that include the technological aspects, such as high-tech disputes. In that regard, it should not come to a surprise that a set of rules that are designed for a fast track or expedite proceeding, streamlined for a quick and efficient resolution of the dispute, are especially suited for disputes in a digital economy. In that regard, as I have said before, I am confident that expedited arbitration rules will soon become the general rule, not the exception, in particular in these matters. Now, for an expedited proceeding to be able to properly perform its function, the use of technology is critical. I would say much more than in an ordinary one. In order to save time and cost, the arbitral tribunal and the party must use technology. In that regard, together with establishing the duty of the parties and the arbitral tribunal to act expeditiously throughout the proceeding, the working group included in the expedition arbitration rules a provision which aim is to assist the arbitral tribunal in streamlining the proceeding and avoiding unnecessary delay and expenses, in line with the objectives of the expedited arbitration. To achieve that purpose, the rules give broad discretionary powers to the arbitral tribunal regarding technology in the conduct of the proceedings. Actually, the working group adopted a specific provision that is related to these powers by the arbitral tribunal in the use of technology. I have to say that there are several members of this group during our session today, including our host, Mr. Takashi Takashima, has a very relevant role in promoting this rule in the broad use of technology by arbitrators. So what is this rule about, or what the rule say? What is the provision intending to achieve? Well, first, to emphasize the broad discretion provided to the arbitral tribunal to make use of a wide range of technological means to conduct the proceedings, including, and this is important, when communicating with the parties and when holding consultations and hearings. Moreover, what the rule does is that mention explicitly that such consultation and hearings can be held remotely or without requiring a physical presence of the parties. The same, of course, is applicable to hybrid hearings. Therefore, any possible discussion as to the powers of the arbitrator in holding remote hearings or hybrid hearings is explicitly solved, and the possibility of holding this hearing as use of technology in that regard become a regular tool, not just for exceptional time as we are living. In line with the topic of the next session, the expedited note that will accompany the expedited arbitration rules reminds that the arbitral tribunal should be mindful that the use of technological means is subject to fairness and to give each party a reasonable opportunity to present its case. In that regard, the provision that I'm referring to requires that the arbitral tribunal give the parties an opportunity to express their views on the use of technological means before adopting any measure in that regard. And also consider the rule considered that the use of such technological means has to be taken into the overall circumstances of the case, a necessary consideration for the appropriateness of such use in the context of the specific case. For the reasons expressed, we consider that the provision that I'm mentioning not only is important for expedited arbitration, but for dispute resolution in general. And that's the reason why the working group also is suggesting its inclusion, the inclusion of a provision along the lines I just expressed in the mediation rules as well, which, as Jay just mentioned, will also be subject to adoption by the Commission in its next session. And with that, I thank you very much, Jay, and pass the word back to you.
Thank you, Andres, for the update. It was an honor for me to actually be servicing the working group as the secretary. So it was a great pleasure, and thank you for the update. Now we'll go back. Now we'll go to Yoshimi to ask the question of whether technology is a friend or foe, or does it really depend on whether you win or not, depending on whether you win the case or you lose the case, and whether technology can become a friend or a foe. Yoshimi, you have the floor.
Thank you. Jay, can you hear me?
We can. Yes, we can.
Okay, good. Thank you for your kind introduction, and thank you for the organizer, MOJ and UNCITRAL, for giving me this opportunity to speak on this legal tech. In fact, Nagashima Ono has been invested in this legal technology. One of my colleagues started the startup company focusing on this technology, legal tech. So I'm very pleased to talk about this legal tech to facilitate the legal services. But the question is, whether this technology is a friend or a foe, and who will know the answer? So due to the time limitation, I just jump into the topic. This legal tech market is growing rapidly. As I just mentioned, one of my former colleagues is now investing in this particular field, and Nagashima Ono and also this startup companies are working together to create new legal tech to support and facilitate our client legal department services. Year 2020, everyone suffered from COVID-19. But due to travel restriction, particularly in the area of arbitration, technology has been highlighted. Importance of technology in settling the dispute has been tremendously highlighted in 2020. I think JIDRC is the sponsor of this event, and JIDRC also provides certain technology services, such as providing file management platform or assist interpreter for the virtual and hybrid hearing. And third, they are interestingly introducing automatic transcript services. Until I think, recently, when we have international arbitration, we retain live note or transcriber services, but now JIDRC is developing this automated transcript services. In fact, this legal tech is not really nascent. It has been there for years, but I think, legal tech market has been growing rapidly. Legal tech has been assisting counsel in preparation for arbitration. I will not go into detail, but just, show you the overview as to how legal tech has been assisting lawyers' work. At the time of debriefing clients, we collect documents and review documents, and we use technology, and certain software company provides the services by which the software is going to automatically create the list of relevant parties and create chronology. And we also heavily use machine translation. And when it comes to, when we first, complete the debriefing stage, then you will move to the second stage, which is, creating the case theory. In legal research field, many law firms have been using database to facilitate the legal research. And recently, some software provides services by which software essentially identifies strengths and weakness of the case, or even predict the potential outcome of the case. Then next, moving to the selection of arbitrator stage, I will leave this to Catherine, because I believe, Catherine is talk about arbitrator intelligence. And next stage, moving to document management. Yes, we use a particular platform to share documents with clients. Oops. And submission stage, in preparing documents, pleadings. Now there are software to help preparing submissions, pleadings, like, managing exhibits and identify relevant exhibits in relation to specific issues. Moving to document production, e-discovery will be taken care by other speakers. So I'll pass to hearing. And hearing, I believe, some other speaker is going to talk about virtual hearing. So again, I'll skip this. But you can see how technology has been prevailing throughout the arbitration proceedings. And when it comes to enforcement, you have to trace the assets and also identify jurisdiction where you mostly where the success rate is high, and identify jurisdiction. Those, database sometimes assist identify those, good jurisdictions. So this is a key point of my presentation. Whether this legal tech is in fact, is a friend or a foe. Now, first I want to highlight, bright side of the legal tech. It will improve the junior lawyers' quality of life. Perhaps, junior lawyers can focus on meaningful work and hold the legal services. The quality and efficiency will be improved, and outcome will be more predictable. And lastly, particularly arbitration, we less trouble and we use less paper, so it will be greener. So this is a bright side. And I want to highlight some of the potential dark side of legal tech. Well, of course, there's always a limitation of technology. You may be able to settle disputes if people meet in person, but perhaps that may be more difficult in a virtual negotiation. And second, cybersecurity issue. Number three, legality of these services. And number four, legal tech may in fact increase the legal fee because you have to pay extra money for legal technology services. And if in fact this legal technology could potentially make things more complicated. And the last point I wanted to highlight, which is the legal tech divide. So some law firms have capability investing in this legal technology, but some law firms may not. And depending on the practice area, legal tech would be heavily utilized, potentially in arbitration, yes, but local litigation, perhaps less. And there might be some divisions among regions. Some regions, legal tech is heavily used. Other regions, legal technology may not be heavily used. When it comes to arbitration, competition is global. You might see the serious consequence out of this legal tech divide among the regions, and also language limitation. Some language are more suitable for legal technology and others are not. So again, this will create, this will actually create the issues among legal professions. So going back to the original question, whether technology is a friend and foe, could be friend and foe. It all depends how we formulate this legal technology. Thank you.
Thank you, Yoshimi, for highlighting that legal tech or law tech or whatever we call it actually applies to the entire arbitration proceedings, and that there is the bright side and the dark side of the use of technology. We'll go into a little bit more into a specific stage of the proceedings, and I ask Rekha to tell us what e-discovery is and how it is done in practice. Rekha, you have the floor.
Thanks so much. Good morning, good afternoon, good evening. Of course, it's great to follow Yoshimi, friend or foe. It really depends on the lens that you're going to be using. And so in the next minutes in talking about e-discovery, we're going to talk about efficiency and cost effectiveness. These are critical focuses, buzzwords even, as we talk about expedited arbitration in particular. Of course, set against party autonomy, scope, and breadth of electronically stored information, or ESI, that becomes applicable in international arbitration at large. There's varied sources of information and guidance that we can get in terms of the rules to adopt, guidelines promulgated by various arbitral institutions, which you will hear more about today, and then other rules that become applicable, either imported through the Lex Arbitri or even through national legislation, and it could be ad hoc in this instance. We're talking a lot more about this in pandemic because as we've all pivoted, a word that's become apropos in these times, how do we reform the process? Where is information stored? It's on computers, it's on networks, it's on hardware, removable disks, backups. The number of places where digital content exists now has only increased exponentially. And then what are the tools that we can best address to talk about all of the concerns? So if we get specific, an issue that comes up when we talk about ESI and e-discovery in general is proportionality. Scope of discovery, it should be proportional to the stakes and the issues involved in the case, of course. But how do you map that? How do the arbitral institutions address that? And then ultimately we have to hone in on, party autonomy and what the parties perceive that they need as relevant. Soft law provides a lot of guidance to this, and it's something that most of us know, but in quick summation, right? IBA rules on the taking of evidence, they point us towards efficiency, economy, recently updated, as well in the height of the pandemic. In July 2020, a number of firms got together and they issued a protocol for online case management in international arbitration. This is juxtaposed with, again, arbitral institutions talking specifically about how do we map all of this content? How do we do it safely and securely? That protocol that I just referenced, though, they're talking a lot about remote proceedings in general, the need for arbitration in general to evolve, to keep pace with regulation and technological processes, digitization overall, and globalization. And so some tips and tricks that protocol offers that I think is helpful in the context of today's discussion is how do we find single end-to-end case management platforms, and how do we choose them? What should the online repository of case data include, in order also to manage all of the different arbitral players in the process? Many of these platforms now involve this ability to manage version control, avoid duplication, maintain a consistent approach in general to how data is handled through proceedings. But parties may not agree on using one platform alone, right? Because they may be worried about breaches of confidentiality and the like. And so really what becomes critical is that we address content storing right at the outset. So it's efficient, it's safe, and it's consistent procedurally. So that overall there's a process for online case management that is transparent. And here, I guess I would note too, cybersecurity has become a major concern when we talk ESI and e-discovery. The ICA New York City Bar CPR protocol helpful in guiding us what are cybersecurity concerns at large. And so how do we map all of that in necessary protocols? But then how do you meet overall? This becomes the question, multiple stakeholders involved in the process. How do we get accountability alongside transparency? How do we map an audit trail of communication and data exchanges easily? Also, how can we get e-bundles through that platform? These are all things when we talk about digitization that become really relevant because it's all possible now in digitized form. And so in general, when we're looking at platform providers that are offering these things, they're looking to data processing agreements, right? Things that we can get at the outset of an arbitration that deals with it. It deals also in talking about built-in video conference software, plugins, and the like to help increase efficiency. But another conversation that you have to have as we delve into e-discovery is, how do you get application with the parties? Should it be something that is mandatory? Should it be opt-out, using a platform as a default option, except the parties are able to opt out? And if they go that route, opt out by agreement or provided by the tribunal, or is it instead opt-in? These are conversations we're having a lot in general at the UNCITRAL working groups, right? Application overall, how do you get consent? If we look at mandatory as an approach, does it ensure better adoption overall, foster broader change? Does it do it more quickly? But then cutting against party autonomy, what are the major issues therein? And so these are just some of the current concerns to think about. There's a lot to talk about as we talk about progress and digitization, and certainly many more conversations to be had. Thanks so much.
Thank you, Rekha. I think you've kind of pointed out all of the different more concrete aspects of what we mean by use of digital technology in the different parts of the proceedings. And your point about opt-in, opt-out actually has a point that we'll discuss in the due process issues, because this is something for the parties to also discuss, to deliberate on. Now we have Liz. We hear about automated cars, we hear about automated contracts, smart contracts. Now, I think Liz will be touching upon what kind of automation that we can think of or what we can expect in the arbitration process. And we note that in the discussions that we are having in the digital economy, we're noting that automation is different from autonomous. And maybe you can give us a little bit of insight on that as well. Liz, you have the floor.
Thank you. And I'm going to start with showing some of the vulnerabilities of the digital world by saying that my broadband is a little bit shady. So could you share my presentation, please? And while that is happening, since we're in multiple time zones, I'm going to go with a neutral hello, everyone. And thank you, UNCITRAL, the ministry, and JIDRC for inviting me to speak here today. This is really interesting. So I am going to be focusing actually a little bit on what you can automate when it comes to institutions. And my name is Lisa, as I mentioned, and I'm head of business development at the Arbitration Institute of the Stockholm Chamber of Commerce, or the SEC. We are one of the world's largest institutions focusing extra on East-West relations and on investment disputes. So we've been talking a lot about what areas of the arbitral process that is or maybe should be automated or enhanced by technology. And automation is obviously beneficial in many areas. And one area where I think the technology is extra beneficial is where the tasks being enhanced are repetitive or of an administrative nature. And at the SEC, we administer about 200 cases per year. So obviously there's quite a lot of repetitive tasks going on. So that means that the area for automation within institutions is huge. And as an institution, we have to navigate this and continuously ask ourselves what should be automated next and what should maybe always be handled by humans. So with that, and moving to the next slide, I wanted to break down what is it that an institution does and what can we automate. If I can have the next slide. So essentially our core offering is we provide the community with rules and instruments, we help appoint arbitrators, and we administer the process. And then to a varying degree, we offer different type of ancillary services and other type of ADR, but for now I'm going to focus on arbitration. So next slide again. Arguably, one of the core aspects of our offering is the rules for arbitration, and when needed, the interpretation of them. So this guides the tribunal and the parties along their journey, hopefully avoiding any Suez Canal moments along the way. The development of these rules would be extremely difficult to do in an automated fashion. It requires creativity, human analysis of the changing world, and its effect on ADR. And you also need, and its effect on ADR, and it also requires to have an opinion on what might be the best way to reach a fair process going forward. This is certainly an area where we need to keep our human brains working, and maybe also an area where we need it the most, as the procedural aspects are changing as a consequence of the increased use of technology. And that means that the process will have different needs, and there might also be different threats to the process, as has been lifted by other speakers today and yesterday. So this is not an area for automation to that extent. So moving to the next slide, which is finding the right arbitrator for the right case. This is already today a combination of humans and tech. It's access of structured arbitrator databases and a human skill to match the right person in the data set to the need of the specific case. And outside of measurable qualifications, we need to take into account case management skill, tribunal balance, and similar type of soft skills, which are still arguably easier to assess by humans. However, this is an area where you find more and more relevant databases, targeting also the softer skills. And I'm sure we're going to be hearing more about that from Catherine later today. But this is also an area that I think is really important that we digitalize to a much larger degree than we do today. Selecting people based on your assessment of them, even regardless of how professional and neutral you may be, it lends itself all too well to hidden prejudice. So while I think it's almost always going to be needed that human touch at the final selection, relevant databases here are hugely important to make sure that we even the playing field for arbitrators, while at the same time also making sure that we find the best qualified arbitrators for the specific case. So third part here, the third big chunk of our offering is the administration of the actual process. And that's also my next slide. So it's almost in the word here, right? This is an area that lends itself really well to automation, both of course when it comes to the institution's own administration, and that's a can of worm, I tell you, and when it comes to the arbitrators and parties. So we could automate workflows, we can manage timetables, we can offer case management platforms like the SEC platform and the ad hoc platform. And just as Reka mentioned, there's a lot of questions around those. And there's so many more solutions here. And I don't want to underestimate the value of human interaction or the effort that it takes to carry out all this automation. I'm knee deep in it, so it's a lot of effort. But I hope this is an area that will look very different tomorrow from what it does today. So where does that leave us? And next slide, please. There's a lot of proposed automation going on, and most of it doesn't actually require very advanced technology. It just requires implementing existing tried and tested technology. So why isn't this already commonplace? I'd argue it's partially due to the dynamics of innovation within arbitration. Solutions supporting the core of an arbitral process generally need to be provided from a neutral position to be trusted and implemented equally. This is the most obvious candidate to do this are the institutions. However, it's generally not been in the DNA of arbitral institutions to identify as tech suppliers. I think this is gradually changing, and that will lead to more and more solutions popping up from our end. But at the core, we're not tech suppliers. For various reasons, including operative and confidentiality concerns, it's complicated for the institutions to join forces when implementing technology, leaving the institutions fairly on their own in their efforts and a fairly small market for their suppliers. This means that stock taking of the relevant solutions out there might be hugely relevant to promote their use. Each institution will otherwise struggle to keep track, evaluate, and implement each solution in a silo. So I want to finish with raising a really great example of this, which is the Protocol for Online Case Management in International Arbitration. It's a joint London firm initiative listing the needs, opportunities, practical guides for institutions to implement digital platforms. It touches on a great lot of the questions that you raised, Rekka, in terms of how do we implement and so forth. And this specific paper came out after we had already launched the SSC platform, so we didn't have as much use for it as we hopefully will have for the things that we will stock take in this group going forward. So I very much look forward to what will be coming here. And with that, I conclude. Thank you very much.
Thank you, Liz. Just to remind those participants, if you have any questions, please feel free to post them in the Q&A or in the chat. I'll collect them in the interim and then pose them to the speakers at the end of this panel. Liz, thank you for your talk about the automations. Hearing what you said about automations and going back to what Yoshimi had said, I think the automations would definitely benefit the junior attorneys who have to do all of the repetitive work that has to be done. So I think that's one aspect that we have to look at too. Now let's move on to Kevin. I know that one area that is not subject to automation is probably hearings, where we need the human bodies to be involved. And can you give us an update on what has been happening to online hearings and how SICAC has been handling online hearings? Kevin, you have the floor. Kevin Nash, you have the floor.
Thanks. Thank you, Jay, and thank you to the Ministry of Justice of Japan, JIDRC, and UNCITRAL for organizing this roundtable. I might start by reflecting on the interventions of Rekka and Liz and the idea of whether or not institutions need to be providing an end-to-end solution. And you can kind of look at it in 4 pillars that a lot of institutions are adopting. You have online filing, you have online document management, you have internal case management, and then potentially the electronic transmission of the awards. What's been really interesting as we go through COVID is what arbitration had to do is it had to respond to a situation. So virtual hearings and participation by remote means was something that was going on here and there for a long time in arbitration. We had the technology available, but now we had to do it because the choice was to interminably postpone a hearing or proceed to a virtual hearing. The really important aspect is what is going to happen once we get back and have the ability to have in-person hearings. Are we still going to be choosing these virtual hearings? For my part and SIC's part, I think that 2020 was a really good example of how well arbitration can work together. It was one of the busiest years on record based on my observations for arbitration centers based in Asia particularly, but also worldwide. And it was really important because it wasn't just about the case numbers. It was about arbitration institutions being able to help the economy continue and resolve the dispute. So it was really good to see. Now, SIC's experience is a bit different because we've had fairly good success with the COVID-19 pandemic. So we are actually having in-person hearings already. So looking back on our hearings in 2020, we still had a majority of virtual hearings. I guess the next procedure up was hybrid hearings, which may be the way going forward, where it's going to be partially virtual and also partly in person. And then we also had physical hearings. This is somewhat the same in the Singapore courts as well. So court proceedings are proceeding virtually, but there are also physical hearings on occasion. Now, talking about what arbitration has done as a practice, we have all sorts of guidance now. Just looking across the institutional landscape, we've got SIC's guide on taking your arbitration remote, SOL protocol, ICC, HKIC, SCC, JIDRC with its virtual hearing. Everyone has provided protocols, and these are being adopted as soft law in SIC arbitrations. So the question is, can we put all of this guidance into a unified legal instrument? One thing, I guess, to look at when we're kind of crystal ball gazing is what is going to happen going forward. We all know the issues with virtual hearings, and there's certain questions that remain. How do we solve asynchronous hearings? How are we going to deal with time zones? We know SIC tribunals are flipping the clock. So one side is able to present in business hours on one day, and then it reverses the other day. This isn't helpful for tribunals who have to be there every day. Asymmetric hearings, because we're having these hybrid hearings. How do you deal with a situation where one co-arbitrator might be available to be in person, but the other co-arbitrator is participating remotely? What we're seeing in SIC arbitrations, for instance, if you had a sole arbitrator, the sole arbitrator could be present in person with both sets of counsel, then co-arbitrators dialing in remotely, and various other permutations. So we know that the virtual hearings are working, but we really need to keep asking ourselves questions. We are very happy to have been a part of the UNCITRAL working group too. And when we're looking at this document, the most recent set of rules is often the most advanced set of rules. So express provisions on being able to participate virtually is important. But this is going to vary jurisdiction by jurisdiction. We need to look at what does the lex arbitri say for the seat of arbitration? What about the potential place of enforcement? How are we handling situations where a party objects, or structural issues where a party wants to participate but may not have the technological means to participate on equal footing? Certainly in SIC's experience, we've been seeing parties that are dialing in by telephone. So you might have one set of counsel that have 3 or 4 screens, and then the other side that is dialing in on an iPhone. That might be a technological discrepancy that the tribunal needs to be addressed. And if there is those structural issues, which we've seen a bit of at times at SIC, what does the tribunal do? How does the tribunal react to that? Is that then time to adjourn the hearing, reschedule the hearing, and then perhaps leverage off the mini arbitration hearing centers that have come to joint arrangements where perhaps a companion arbitration hearing center can then, submissions can be made at that hearing center. So I suppose looking forward, what is going to be interesting is how we get back and what is going to be the main mechanism. Is it going to be in-person hearings, hybrid hearings, virtual hearings? The way that I always position this is that what we are doing is we are advancing to get back to the core principles of arbitration, cost and time efficiency, looking at greener arbitrations, making things quicker. And how is this impacting on arbitration practice? I think at SIC that we've seen a change in the way that parties are making submissions. So are there going to be more streamlined submissions, somewhat abbreviated opening statements? Is there a bigger need for post-hearing submissions to make sure that all the issues have been addressed? So it's an exciting time for arbitration, and it'll be even more interesting once everyone has the right to be in person, but may still choose virtual hearings.
Thank you, Kevin. It was a very interesting, how would you say it, a summary of what's happening with regards to online hearings. Now, we've also heard a lot about soft law protocols that has been developed by different institutions. And I was at the venue of the ADR conference in 2018 when the SOL protocol was introduced by Kevin Kim, who was participating remotely, I believe, at that time. Kevin, can you tell us what the SOL protocol on video conferencing is about, why you proposed it, and were you able to expect that COVID-19 was going to hit us in 2020, and that's why you proposed it in 2018? It's just the question that I have for you. Thank you, Kevin. You have the floor. Kevin Kim, you have the floor.
Thank you very much. It's a great honor for me to participate in this event. The SOL protocol has had a remarkable journey over last 2.5 years. it was released in 2018, about 2 years ago. But it seems like much longer because of events happens. So many things happen so far. Let me show you the picture of the conference. This is like now you see maybe more awkward to see actual participation by the speakers, but at that time there's very old things. A moderator is moderating the session by video. I was in London actually I was attending the hearing, and 3 a.m. in the morning in London time I'm moderating session. Was conducted the ADR conference in November 2018. When I proposed the video conferencing protocol, people just say that, oh, we have so many guidelines, we have so many protocols. I'm not sure we really need anything more on the video conferencing. The reason why I proposed the video conferencing protocol is that we are going to use this technology more often. That's going to happen, but the printing is actually can be done by video. Is normally have no problem as long as connection is good. But when you have conducted hearing, particularly witness examination, you have issue of integrity. How you ensure that witnesses properly testify what he or she want to say. So that is we prepared the set of technical requirement and the laundry list what we have to check for the witness examination. So that was the prepared, and we actually prepared some video clip to show that what actually happens in the video conferencing, and then we actually try to adopt those laundry list as a protocol, as we call the SOAP protocol. Let me show you this next slide. I'm sorry. Okay, this is the SOAP protocol. SOAP protocol covers mainly focusing on witness examination and the checking video conferencing venue. And there was the item of the observers, so who just make sure that everything is properly done. And there's how we manage documents, how we share the documents, what is technical requirements, and the test conferencing, audio conferencing, backup, interpretation, recording, preparatory arrangement. You feel like that, this is what we are doing now. But at that time, 2018, people are not sure whether we really need all those things. But I'm really happy to report that in actual experience in 2020, when you are forced to use the video conferencing as routine things for the hearing, those checklists really works, and then the other institutions adopt the same or similar things, and then particularly me, I'm sitting in Asia. I have to participate hearings in Asia and Europe and America. I normally attend in a very awkward time, but last year alone, 2020 alone, I have 11 hearings on the merit. It is impossible if we don't have such a technology assistance. Even though I'm free to travel, it's difficult, very challenging to have 11 hearings on the merit. I have one case where maybe I can show you my facility. So I'm sitting in this room now, if you can see me. So I'm sitting here traveling all different countries. I had one case where we need 40 depositions and 3 hearings on the merit on the particular case. And deposition is conducted in Hong Kong, Shanghai, Seoul, and DC, and New York. That all done within 4 months. It's impossible if you want to travel, if you want to do the in-person hearing. So what I want to say is not just because of Seoul Protocol, but because of the COVID-19 situation, we luckily adopt new technology very actively and use the technology. That technology will help the arbitration more efficient and speedy, and then that the more support the original idea of arbitration. So that is my experience so far, and I hope the Seoul Protocol is useful to everybody. Thank you very much.
Thank you, Kevin. I think the two Kevins have kind of highlighted that the use of technology has been kind of embodied and used by institutions and practitioners to make efficient use of them. And then they have been embodied in practical protocols, which actually are providing some practical solutions on the use of technology. And I think this is an area that UNCITRAL may wish to look into on whether there is the need for any harmonization and whether it could be modernizing the different use of technologies in the arbitral proceedings. Now, we've talked about institutions providing end-to-end solutions. Now we'll look into, I have the floor, I'll pass over the floor to Catherine Rogers. Now, in the context of digital economy, we use AI to mean artificial intelligence. But here, I think we're talking about AI as the arbitrator intelligence, which is often referred to as Tinder of arbitration as well. So Catherine, can you give us a little bit of a feedback on what arbitrator intelligence is and what you are trying to do?
Thank you. Thank you for the kind introduction, and I'm grateful to be here. I'm going to try and very quickly suggest what I think is the technological future that will affect how arbitrators are selected and improve the experience for all. So I'm going to share my screen. And what I'd like to do is start us with some comparisons about how our industry measures up on connecting technology to some of our essential functions. So it used to be that if you were somebody who needed a ride, you had to find someone who had a car, and you had to do that one-to-one. But today, of course, we know that there are a number of ride-sharing apps that connect people who don't know each other, but who have overlapping needs. Same thing with, for example, somebody who needs a house and somebody who someone who needs to find a place to stay and someone who has a home to stay. Now we know, for example, that home sharing like Airbnb can connect them. In international arbitration, as we know, most of the key information, you might collect what's publicly available, and as was already explained, there are increasing number of databases that kind of pull into one place the information that's publicly available, such as awards. But what is the key information that people usually want when they are selecting arbitrators is not what's publicly available, but kind of the insights, the individual feedback and evaluative information. And today, the technology we still use to get that is 19th century technology. It's the telephone. We have smartphones, but it's the same idea that you have to know someone, you have to find someone who knows that arbitrator and connect with them to see what their experience was, what their impressions were of not only the substantive decision making, but also the kind of soft skills that were already mentioned by Lisa. So what we do at Arbitrator Intelligence is we do what Uber has done for ride sharing, what Airbnb has done for house sharing, and that is we've created an online platform that instead of having to call individually, we are linking together people all over the world who can share their insights and therefore accumulate them and provide them in a more useful format. So the way we do it, pardon me, is we've developed something called the Arbitrator Intelligence Questionnaire, or AIQ is what we call it. It's a questionnaire that is online, as it's suggested. It is both confidential and and anonymous, so the people who submit the information do so anonymously without their name being attributed to the feedback that's given. The questionnaire has a series of questions that are both factual. What were the names of the arbitrators? What were the dates? What was the amount requested, the amount awarded, costs and fees, the arbitral institution, the legal seat? We do not ask the parties' names, and we do not associate the names of the attorneys or the law firms with the feedback that's provided. So it's confidential and anonymous, but what it allows us to do is collect systematically, case by case, information, both those kind of hard facts, but also the evaluative information that people need. One of the most important questions we ask is, did you, from your own perspective, win or lose? Because even if you have the final award, you can't necessarily understand whether the parties, each of the parties, thought that they had won or lost. That's oftentimes a very subjective thing, but it can affect their analysis or their perceptions of the fairness of the proceedings, of certain procedural rulings. So we ask a number of both evaluative questions, factual questions. We then analyze that data. We generate reports based on that data, and the reports are then available for everyone, and they can be used once again to start the cycle all over again. The importance here, I want to say, of this technology is I do think it is going to revolutionize how arbitrators are selected, and is going to address some of the most important concerns that are actually currently being focused on in Working Group 3 with respect to investment arbitration, but it's almost more acute with respect to commercial arbitration. One, we talk about expanding the pool of arbitrators. As the number of arbitrations grows, we need more arbitrators, and we need to identify who are the best among them to include in that expansion. Expansion, of course, also implies expanding the diversity. The fastest growing regions in terms of case growth in the world are not North America and Europe. They're regions outside of North America and Europe where the number of arbitrators are noticeably less concentrated than there are North American and European arbitrators. That, of course, needs to be resolved. But how can you know and have confidence appointing new diverse arbitrators if you can't find out this crucial information about them? I think also this kind of information creates greater accountability among arbitrators. They are not licensed. Unlike lawyers, they can't be disbarred, they can't be sued for malpractice, and the lack of information impedes even reputational sanctions. So accountability of arbitrators, I think, will also be improved. What is it that looks like what we produced? So this is an example with Fernando Cantuarias, who's a very prominent Peruvian arbitrator. This is just a dashboard from his report. You can see that we can collect and analyze information that you otherwise, no matter how many phone calls you make, couldn't do. We have 25 AIQs from 19 different cases. As far as I'm aware, all 19 of these cases remain secret. They are not publicly known. But look what we can do. We can analyze. This is a question whether you won or lost. You can see respondents in the 20 or so cases we have seem to think they prevailed more. Why? You can find other data that might suggest it, which is most of the results in these Cantuarias arbitrations we have were either decisions for the responding party, 0, or less than 50% of the amount requested. We also have reports on investment arbitrators. Once again, here we rely on the publicly available awards, but we can do analytics that are otherwise difficult to do if you just read through the awards one by one. So for example, we can aggregate all the different categories of claims. So direct expropriation, indirect expropriation. On the top, you see how many times the claims were raised. And then you can see, according to the colors, whether they were granted in part, or denied. The same thing we can do with jurisdictional claims and other types of issues in the case. We can also, time is a very important issue and one that's been a big concern. We can calculate different factors that might affect the timing of cases. Here it's dissenting opinions. So with that, that was a quick preview of what we're doing with arbitrator intelligence, trying to bring technology and innovation to the arbitrator selection process in order to improve the efficiency and fairness and diversity and accountability for all. So thank you very much. For more, please do visit our website.
Thank you, Catherine. I think you've highlighted how much information is a valuable asset in the digital economy. And it is actually something that we're looking into about using big data as a big information thing, and particularly on the use of information in the context of arbitration selections. So I think we started a bit late. I think rather than going into the Q&A, which actually delves into some of the topics that we'll be discussing in the due process, I'll just pose this question to all of the speakers, and maybe we can continue that discussions in the roundtable discussions, which will follow session 2. But I think what we've seen is that there are a number of players in the in arbitrations that are actually driving the use of technology in arbitration. I found that it's the parties, it's the institutions, it's the new tech companies, it's the tech suppliers that are providing these inputs into providing technology in arbitration proceedings. But my questions to all of the speakers for session 1 is, who would have the biggest role? Would it be the parties that want these services, or would it be the institutions that are competing with each other, that are trying to provide such services? Or is it companies like Arbitrator Intelligence, which will be coming up with new ideas on feeding into new technologies that can be used in the arbitral proceedings? So this is a question that I'm posing to you now, but I will not open the floor now because we're running a little bit late, though we did start a little bit late. But I would like to go straight to session 2 on due process, and I'll go back to the speakers for session 2 during the roundtable discussions that will follow in about an hour. Would that be acceptable to all of you? Thank you. I would ask the session 1 speakers to turn their cameras off now, and I'll now invite the session 2 speakers to turn their cameras on. And then on this session, we'll be looking into how to ensure due process and fairness in arbitral proceedings. As I noted, the use of technology has raised a number of concerns about whether due process is being preserved. But my question to you, I mean, as a general question, is we talk about digital divide, we talk about digital injustice, but does this mean that we need to come up with a new definition of due process in the digital economy, and how you see due process being preserved in this context? This is a general question, but now I open the floor first to the first speaker, Jerry, to give us an idea of what's happening in ICSID, particularly with the rules, proposed rules change in the ICSID context. Thank you,
Wonderful.
Jerry.
Thank you so much. So I'm going to try to share my PowerPoint. Great. So on behalf of ICSID, I would like to thank the Ministry of Justice of Japan, the JIDRC, and UNCITRAL for the opportunity to give a short presentation on the case management conference provision proposed as part of ICSID's rule amendment process. Okay, so on the slide, you will see the current text of the proposed case management conference rule. I'll be using CMC for short. A case management conference provision has been part of the ICSID rules amendment since the first working paper in 2018, and it is widely supported. The provision is part of a philosophical change in some respects, aiming to make tribunals more proactive in terms of reducing the length of proceedings and costs. It is intended to help counsel by providing focus on the issues which the tribunal thinks can be resolved or needs further attention. Some can view it as an important addition to due process, as it is an opportunity to move the case forward efficiently. The provision is based on the very successful use of CMCs in domestic courts, where judges have taken a leadership role in ensuring progress in the case. Okay. Although the new ICSID amended rules are not yet in place, in the past few years, we have seen a handful of tribunals beginning to use CMCs. This practice has increased during the pandemic, perhaps because we now see how easy it is to hold these meetings using remote platforms. So when are CMCs scheduled and held? Generally, tribunals will put a placeholder for a CMC in the first procedural order. Typically, CMCs will be scheduled shortly after the first round of written submissions. Some tribunals prefer to schedule out several CMCs at different points in the proceedings and then check in with the parties to see if it's necessary to hold the pre-scheduled CMC. So what actually happens at a case management conference? First of all, I'd like to talk about how they can be held. They can be held in person, by telephone conference, but most of them have been held by video conference. I would say the grand majority. So before the CMC is held, the tribunal and the parties will decide on the agenda with the topics to be discussed. While the tribunals generally propose the agenda items, the parties are always invited to add additional matters, which is another example of how due process is built into this procedure. During the CMC, tribunals will typically hear submissions from each side and then ask the parties targeted questions. This process allows the tribunal and the parties to have a collaborative dialogue that assists in narrowing the issues and possibly finding agreement on certain matters. So what topics have been covered recently by CMCs? Typically, they have dealt with procedural issues, including the procedural calendar. Tribunals have also used CMCs to discuss the scope, necessity, and timing of further written submissions. Confidentiality issues have also come up, document production, as well as hearing-related matters, especially recently, such as where will the hearing venue be, the mode for the hearing, will it be remote, in person, and then also touch upon witness examination issues. So how will things change once ICSID's new rules are adopted? So to make proceedings shorter and less expensive, the proposed new CMC rule promotes more active management of the proceeding by the tribunal. Under this rule, tribunals and parties will be required to have at least one case management conference after the first session. So that means the first session doesn't count in addition to that. So while there's no set procedure outlined in this rule, we expect the CMC process to remain the same, with the tribunal and the parties agreeing on agenda items beforehand, and then the parties making oral submissions at the CMC, followed by questions from the tribunal. Given the increased comfort with remote hearings, especially for procedural matters, we anticipate most CMCs will likely continue to be held remotely by video conference. Post-rule adoption, what may be different is the subject matter of these case management conferences. The proposed text gives examples of topics to be discussed, including identifying uncontested facts, clarifying and narrowing the issues in dispute, and addressing any procedural or substantive issue related to the dispute's resolution. So that last category is pretty broad. So we have seen CMCs used to date primarily for things like procedural scheduling, but we hope tribunals and parties will become even more proactive under the new rules and use this mechanism to ensure an overall efficient proceeding. So thank you so much for your attention, and we hope that this overview is useful for your future discussions.
Thank you, Jerry. I think one key aspect of due process is for the tribunals to actually consult with the parties in the conduct of the proceedings. And you have highlighted that the CMC can be the platform to consult with the parties in a number of aspects related to the proceedings. So I think that's a point that we need to get. Next, we'll go to Mr. Masato Dogauchi towards a smart arbitration, streamlined and a predictable procedure. So we're not talking about technology, but we're talking more in the general sense of arbitrations and how to streamline that. Mr. Masato, you have the floor.
Yeah. Thank you, Chairperson, and thank you for all. It is my great honor to make a presentation in this session. The topic of which due process and fairness. So, yes. I'd like to present how civil law style arbitration would achieve the value of due process and fairness. The method of the civil law style arbitration is different from that of the common law style arbitration, which is the dominant model of arbitration today. But the goal is the same. The merits of the civil law style arbitration is that it would provide the business community with a more party-friendly dispute resolution in terms of cost, time, and predictability. The common law style arbitration tends to have some problems, even if you use high technology. First, a huge volume of documents is submitted and many witnesses are examined in order to assert and prove all possible factual and legal issues. Second, lengthy arbitral awards on these issues are produced at the end. And high cost relative to the amount of claims is to be borne by the parties. In order to address these problems, the Japan Commercial Arbitration Association, JCAA, introduced the interactive arbitration rules in 2019 as one of the options for the parties, which Mr. Takatori touched upon briefly yesterday. Thank you, Yoshi. The interactive arbitration rules has two distinctive provisions on dialogue between the parties and the tribunal in the process of the proceedings. I mean, at least twice in the proceedings. Article 48 provides the first dialogue, according to which the tribunal is obliged to, at least at the earliest possible stage of the proceedings, summarize the positions of the parties regarding the factual and legal basis of their claims and responses, and tentatively ascertain the factual and legal issues on the basis of the summarized positions. It is important to note that the positions and issues shall be presented in writing, and the parties are given an opportunity to comment on the positions and issues. Regarding the second dialogue between the parties and the tribunal, according to Article 56, the tribunal shall, prior to the time of its decision as to whether witness examination should be conducted, prepare and give a little summary to the parties on the following items. First, the factual issues that the tribunal considers important and its preliminary view on them. Second, the legal issues that it considers important and its preliminary views on them. And third, any other matters that the tribunal considers important. The parties are given an opportunity to comment the preliminary views, and of course, these preliminary views shall not be binding upon the tribunal's subsequent decisions. The objectives of these dialogues are as follows. The first objective is to facilitate the tribunal and the parties to share the outlook of the case. Second, to reassure the parties that the tribunal has an accurate understanding of their assertions. Third, to allow the tribunal to re-examine its understandings by learning the parties' responses. Fourth, through the second dialogue, to assist the parties to consider the necessity of the witness examination, and it is to be done to determine who should be examined. Fifth, to give the parties an opportunity to reconsider their strategy and tactics to present their cases effectively and efficiently. Sixth, to allow them to consider any possible settlement without having a final arbitral award. Seventh, to shorten the time for drafting arbitral award by referring to the written communications. I have no time to discuss, but similar rules are found in the Prague rules and the DIS, the German Institute of Arbitration Rules, both of which are made in 2018. My conclusion is as follows. Disproportionately lengthy and expensive resolution of dispute would be against the due process of law. The JCAA interactive arbitration would enhance parties' predictability, shorten the time of proceedings, and consequently achieve a cost-effective resolution of a dispute. Such civil law style procedure would secure the true due process in conformity with a sound business sense. I'd like to add the real case. Just one case has been conducted according to the interactive arbitration rules in the JCAA. In this case, the parties agreed to be subject to the interactive rules after the application was made under the default JCAA rules, that is, commercial arbitration rules. I have introduced an extreme model of civil law style arbitration. In JCAA arbitration, it is one of the options among 3 sets of rules. I think that the task of the UNCITRAL is to accommodate 2 styles of arbitration, civil law style and common law style, and to find a good method of arbitration for the users. Thank you for your attention.
Thank you, Mr. Dogauchi. I think your presentations and Jerry's presentations kind of confirms the discretion of the tribunal to conduct the proceedings in an appropriate manner as they consider appropriate, but to ensure that the parties' views are taken into account in that kind of a discretion. Now, Mr. Dogauchi mentioned the DIS rules, and now it's a good time to actually pass the floor to Mr. Chungkyung Paulus Seo from DIS to give us an idea about, I think you wanted to focus on the balancing of the efficiency and due process. So you have the floor.
Thank you very much, Jay. Hello, everyone. It's an honor and privilege to speak to you today. Well, due process and efficiency is always referred to as a balancing act. And often it is said expedited arbitration aims at faster and cheaper proceedings. Trade-off for efficiency are limits on due process. And I would like to ask, is it always so? COVID-19 has challenged international dispute resolution to find new solutions, to find ways to keep the system running. It took advantage of technological advancements in our truly digital era. We have heard a lot of that yesterday and today. Well, extraordinary situations demand extraordinary solutions. And to my mind, this is not limited to technological or digital solutions. This is actually a great opportunity to think out of the box. International arbitration has long benefited mostly under the influence of the Anglo-American approach. And to make sure this is not to deepen the divide between Anglo-American law approach and the civil law approach, but it is necessary to supplement whatever functions well in comparative systems, to some extent cross-fertilize each other, and to add elements to the efficiency agenda. Today, I would like to present to you one feature from the civil law approach as a takeaway, and I'm very thankful to Mr. Dogauchi that he laid somewhat a good base for that. Thank you very much. We are constantly discussing about enhancing efficiency and quality and reducing costs at the same time. To our mind, the best way of saving time and cost is just not incurring them. Key to this is, from our experience, early conflict resolution. Geraldine just highlighted the importance of case management conferences to enhance efficiency in many ways. Even it was included to issue resolving disputes. Now, this is based on the understanding that the case management conference is not a purely administrative matter in which dates and time limits are discussed, but the CMC set stage for the arbitral tribunal inter alia to provide a preliminary assessment of factual and legal issues, which are of course non-binding and provided when all parties consent thereto. Such assessment can be, and in a great number of cases is, basis of settlement negotiations between the parties. Well, beyond the CMC, in most continental European countries, well, I just noticed that the majority of this panel have a civil law background. Well, in most continental European countries, state court judges even can make settlement proposals. And they do. The German Code of Civil Procedure even instructs the judge to work at all times towards an amicable settlement of the dispute. According to the numbers of the German Federal Office of Statistics, more than 50% of court cases in Germany are settled. No wonder that DIS reflects this in its rules, namely to encourage settlement at any stage of the proceedings unless any party objects thereto. This approach is deemed to be unthinkable among Anglo-American lawyers or even other arbitration lawyers. Though before I continue, please allow me to quickly share a quite sexy number with you. 72% of cases terminated under the 2018 DIS arbitration rules were terminated without a final award. This means 72% of all cases have been terminated early. From these 72%, taken the cases which have been constituted, a majority of 58% were terminated even before a hearing has taken place. These numbers do not allow to draw great conclusions, but modestly show and at least indicate that such means of early conflict resolution and the efforts of civil law arbitrators do account for a number of settlements. And in that sense stands out with this civil law element. Now, turning to the question of due process, the following doubts and concerns are typically expressed by Anglo-American lawyers. The arbitrator is considered biased if he or she proposes a settlement, or the role of the arbitrator is to merely assist the parties finding a settlement whenever they actively ask for it, but not in a proactive way. The arbitral rules do not allow it. Without anticipating what Nusha and Giacomo will share with you in the context of due process and remote hearings, I would like to draw your attention to the broad discretion of arbitral tribunals in the conduct of proceedings, and would rather appeal to robust case management decisions in this regard. What is needed in the international arena on early conflict resolution is awareness and openness. To be aware that international arbitration is not an Anglo-American court trial, that most arbitral rules do not prohibit proactive settlement or proactive case management. And in cases where arbitral rules are tacit, proactive conduct to early conflict resolution is viable. Many civil law arbitrators show that, and there is no reason to fall into a settlement paranoia. So once awareness and openness is given, acceptance should be reached, and with the hope that rules on alternative dispute resolution may include a promotion of early conflict resolution. Thank you.
Thank you, Paulus. I think you've highlighted the fact that we're looking not only into due process in international arbitrations, but we're talking about due process in dispute resolution as a whole. So we have to take into account other means of dispute resolutions, which has also been highlighted in the Q&A and in the chat as well, because there's a lot of comparison between dispute prevention, mediation, and arbitration. And I think when we're considering due process, I think we have to consider the entire spectrum of dispute resolution as well. So thank you for your presentations. As you kind of hinted, we'll go into a very actual case of what has been handled, how the courts have handled remote hearings in its case. Next speaker is Ms. Nisha Basi. So you have the floor, please.
Thank you very much, and good morning, good evening to everyone. Thank you very much to the Ministry of Justice of Japan, UNCITRAL, and the JIDRC for inviting me. Before I go to the specific case I'm intending to discuss, I just wanted to remind everyone of the starting point. Paulus has already referred to this balancing act, which I call the tension in the legal framework of procedural due process. You will be familiar with Article 18 of the UNCITRAL model law, which provides for the equal treatment of the parties and is a mandatory requirement of procedural due process. The parties shall be treated with equality, and each party shall be given a full opportunity of presenting his, I say her, case. So I underline full opportunity because I want to come back to this again. In addition, Article 19 of the model law, and here I refer to the first paragraph, concerns the determination of rules of procedure, and this goes to the core of the parties' procedural autonomy. Subject to the provisions of this law, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. Against that, Article 19, second paragraph, here the first sentence, failing such agreement of the parties, the arbitral tribunal may, subject to the provisions of this law, conduct the arbitration in such manner as it considers appropriate. So here comes the broad powers of the tribunal, but these powers are not absolute precisely because of the mandatory requirements of procedural due process and the parties' procedural autonomy that I just referred to. Moreover, there are certain laws in certain jurisdictions. There are arbitration clauses, either in BITs or in commercial contracts that provide for limitations with regard to the time for rendering the award. And this puts the pressure on the tribunal to produce an award that will not be set aside at the place of arbitration. And that pressure is transformed into procedural measures that the tribunal can take and will need to adopt, but to some extent might encroach on the parties' mandatory requirements of procedural due process and procedural autonomy of the awards, of the parties, sorry. The New York Convention looks at it also under Article 5.1b, that an award may not be, that an award may be refused enforcement when the party against whom the award is invoked was unable to present his, I say her, case. And this is the point that I had emphasized earlier in Article 18 of the UNCITRAL model law, shall be given a full opportunity. Article 5.1b of the New York Convention speaks about unable to present the case. And also Article 5.1d of the New York Convention foresees that an award may be refused enforcement when the arbitral procedure was not in accordance with the agreement of the parties, or failing such agreement was not in accordance with the law of the country where the arbitration took place. Solving the tension, the parties' rights and autonomy, and the tribunal's powers, I think, is by actually distinguishing between real due process and ordinary process. And in the context of ordering remote hearings, when one party objects to a remote hearing, I will look at the Austrian Supreme Court decision. Just to go back to the New York Convention, the ICA guide to the interpretation of the 1958 New York Convention recommends to judges that the convention does not intend to give the losing party a right to an appeal on procedural decisions of the arbitral tribunal. Rather, Article 5.1d is aimed at more fundamental deviations from the agreed procedure. And there are examples that do not fall under these deviations, these fundamental deviations. For example, in a case where the tribunal did not hold an oral hearing, that is pre-pandemic, so it was really about holding a hearing at all or not, or disregarding new evidence, where the court provided that this is in line with the arbitration rules as agreed by the parties. Where a fundamental deviation has been successful in objecting to the award was, for example, when indeed the procedural law at the seat was not applied at all. Not under the New York Convention, but under French law, also deviation was considered and a due process violation was considered in case of a surprise decision that the tribunal decided on a matter without going first back to the parties, asking them for their views on a methodology of calculating damages or of awarding specific damages. So in relation to remote hearings, last year, the decision of the Oberste Gerichtshof of Austria from July 2020 was quite an important decision indeed, because the Supreme Court of Austria was faced with the challenge to the tribunal, not to the award, to the tribunal, that the tribunal had decided in violation of due process rights of one of the parties. And the Supreme Court decided on rather pragmatic issues on the conduct of remote hearings, which I call the digital due process, and which in my view fall into the category of ordinary process. Two of these issues are relevant. In particular, one was the unequal treatment because of an early hour start of the hearing. So for all our North American friends, this is important for you, and the undue influence of the witness. What did the Supreme Court do? It actually compared arbitration to litigation and said, we are looking now at litigation court proceedings which are taking place in a remote platform. And it looked at the time zone issues and said, well, the parties knew of the geographical distance when they agreed to the Vienna arbitration rules with the seat of the arbitration in Vienna. And the early rise at 6 a.m. for US counsel was less burdensome than traveling to Vienna. With regard to the witness tampering, it came up with very pragmatic hands-on suggestions how this can be avoided, but also stating that witness tampering can happen also in physical hearings and is not something special to remote hearings. So in my view, I think there is no need for a new definition of due process, but rather a more conscious distinction what is really ordinary process versus due process. Thank you very much.
Thank you, Nusha. I think the one point that I wanted to mention with regard to the Austrian case is that when the states implement the model law on arbitration that UNCITRAL has provided, sometimes they tweak it a bit. And I think in the Austrian law, they did tweak Article 18 to mention fair proceedings rather than equal treatment. So there is a little bit of a difference there. And I think the next presenter actually will give us a bit of a more insight on how remote hearings are handled in the different jurisdictions. So I give the floor to Giacomo to present the ICA study on the due process and remote hearings in a number of jurisdictions. Giacomo, you have the floor.
Thank you. Good morning, good afternoon, good evening to everyone. It is my great pleasure to contribute to this event. And first of all, I would like to thank UNCITRAL, the Ministry of Justice of Japan, and the Japan International Dispute Resolution Center for this very kind invitation. So the topic of my presentation is the interplay between remote hearings and due process, but differently from my colleague Nusha, I will address this topic drawing from the preliminary results that are emerging from a research project that I am conducting under the auspices of ICA, together with my two co-editors, James Osking and Yasmin Lalou. I will now try to share my screen. Great. Okay, so this ICCA project tackles the new legal questions posed by the increased use of fully remote arbitral hearings due to the COVID pandemic. So these questions revolve around what we believe to be one core question, whether a right to a physical hearing exists or not in international arbitration. The methodological assumption of this project is that there cannot be a single transnational answer to this question, and that therefore it is inevitable for arbitrators to look at, on the one hand, the law of the seat of the arbitration, that is the law governing the arbitral proceedings, and on the other hand, the law of the place where at a later stage, recognition and enforcement of the award may be sought. Now, as to the scope of the project, what we did was to put out a call for expressions of interest to answer to a standard survey questionnaire. The response to our call was overwhelming, around 150 applications covering 82 New York Convention contracting states. As of today, we have released and published 46 national reports on a dedicated page of the ICCA website, and all these would have not been possible without the extraordinary support that we are receiving from ICCA, and in particular from the president of the ICCA governing board, Lucy Reed, and as well ICCA Bureau's executive director and deputy executive director, Liz Bosman and Lisa Bingham. So the preliminary results emerging from these reports basically confirm that our methodological assumption was correct. This is particularly evident if we look at two basic scenarios. The first scenario is the one discussed by Niusha, whether the arbitral tribunal can conduct a remote hearing notwithstanding the objection of one of the party. The second scenario is whether the arbitral tribunal may order a remote hearing contrary to the parties' agreement to hold a physical one. I will focus on the first scenario in this presentation. I will be happy to tackle the second scenario if we have time during the Q&A. So for the sake of convenience, I will try to illustrate the different answer we are getting along a continuum by ideally placing the jurisdiction along this line segment with two opposite ends. On the left hand, we see the jurisdiction where remote hearings are incompatible, or the reporters argue are incompatible with the law of the seat. On the opposite end, we have jurisdictions where remote hearings are per se compatible with the law of the seat. Midway, we find the position of those jurisdictions where these legal questions remain unsettled. So let's first focus on the left end of our continuum. Here we have reporters suggesting that notwithstanding the lex arbitri does not provide expressly for a right to a physical hearing, a right for a physical hearing can be notwithstanding inferred by way of interpretation of the lex arbitri. Now, the reasonings for inferring the existence of a physical, of the right to a physical hearing varies among jurisdictions. For example, in Tunisia, the argument goes that because of due process and the procedural rules safeguarding due process, remote hearings are incompatible with that legal system, while in other jurisdictions such as Sweden and Vietnam, the reasoning is more based on a systematic interpretation of the Code of Civil Procedure. Now, moving to the midway of our segment, we find a few model law jurisdictions where it is unsettled whether the provision of Article 24, paragraph 1, granting the parties the right to request an oral hearing, translates into a right to request a physical one. The majority of model law jurisdictions answer in the negative, but we have jurisdictions such as Denmark, Bahrain, Germany that interpret this part of Article 24.1 of oral hearing as not necessarily compatible with the possibility of holding a remote hearing. And so they submit that this question is unsettled. Now, quickly moving to the most interesting right side of the spectrum, the majority of the surveyed jurisdictions suggest that remote hearings are compatible with their arbitration laws, although with the essential limit that is illustrated with this red line of the arbitrator's duty to safeguard the parties' due process rights. Now, this jurisdiction cannot be put in the exact same position along this segment because of the variation we are receiving from the reports. For instance, this variation depends on the lower or higher threshold used by courts, national courts, to assess whether there was a violation of due process. And the second reason for this variation is exactly what has been discussed by both Paulus and Niusha, the different way national courts discharge the balancing activities between the different due process requisites. On the one hand, the right of the parties to have a full opportunity to present their case. If we give more weight to this right, then it will be harder for arbitrators to impose a remote hearing. On the other hand, if we or the national courts give more weight to the access to justice or the arbitrator's duty to conduct the proceeding in an efficient manner, then we have a strong ground to supersede the objection of one of the parties to the remote hearing. Very last point, the very end of our continuum are those few jurisdictions where remote hearings are considered to be per se compatible with the law of the seat. This is the case, for example, for Indonesia, where the reporter submitted that due to the lack of any reference to due process in the arbitration law, there is no issue. Basically, remote hearings are per se compatible with Indonesian law, but it's also the case of Switzerland, where there is a consistent line of decisions of the Federal Supreme Court that ruled out the idea that conducting an oral hearing, even if requested by one of the parties, is required as a safeguard of the parties' due process. Given that, a fortiori, the national reporters submit that this implies that remote hearings are fully compatible with the due process requirement. So I'll stop here my presentation. I thank you very much for your attention, and I will be more than happy to answer your questions later. Thank you.
Thank you, Giacomo. I mean, considering that most of the jurisdictions that you mentioned are model law jurisdictions, I think the different approaches of the courts is something that we would need to look into a little bit more carefully. Now, going into a little bit more in detail, I think Juditha would be focusing on on how cross-examination is to be done in the remote hearings. But Juditha, you have the floor.
Thank you very much, and thank you for the invitation to participate. Thank you to the organizers. This is really a very interesting event. Yes, I would like to focus a little on the issue of confidence, actually, that remote hearings may or may not enjoy with the parties, because of course the legal basis for forcing the parties to accept remote hearings is an extremely interesting and relevant topic. But if the parties agreed to remote hearings, then there would not be such an impelling need to have a legal basis for that. Problem is that the parties do not necessarily always agree to having remote hearings, and I would like to understand or to discuss a little bit why, particularly with respect to witness evidence. Now, in my very anecdotal own experience, I see that it's about 50-50. Some parties agree without any problems whatsoever to fully remote hearings and are happy with that. And some parties do not wish to have a remote hearing, and they go on and postpone and postpone and postpone. Now that we have been postponing for 1 year, actually. So a slightly less anecdotal level of experience. I was talking to Stefano Azzali of the Milan Chamber of Commerce the other day, and he told me that about 80% of the cases that they have had since in the year 2020 has been held completely remotely. Completely remotely, it was 76%, and semi-remotely it was 6%, showing that in the Milan Chamber of Commerce there is availability to remote hearings, whereas in the Scandinavian tradition, particularly when it comes to ad hoc arbitration, there is more skepticism. What is this skepticism due to? In part, it's due to concerns about the creditworthiness of testimony given remotely, and then we have the known remedies. You can have a camera showing the whole room the witness is sitting in. You can have a representative of the other party sitting in the room where the witness is making his testimony. This is not so difficult to cope with. The main concern is actually about the lack of immediate contact between the tribunal and the witness. There is this belief that the arbitral tribunal is very well apt to understand whether a witness is telling the truth or not, and that this use of the psychological insight of the arbitral tribunal may be impaired by having a digital or a virtual hearing. So to address this concern, I'm thinking that technology or remote hearings should not be used simply as a technological substitute of a physical hearing. We should try to organize the witness evidence in a different manner so that we can address this suspicion about the lack of immediate contact with the witnesses. And how we can do that? Well, we can make a more extensive use of written witness statements to be given in advance, so that the oral hearing can be used to focus on the cross-examination. We can give more power to the arbitral tribunal to be active in the questioning of witnesses on the basis of the written witness statements. But these things that I'm saying now, written witness statements and active role of the arbitral tribunal, they can be considered as quite unacceptable in some legal traditions. And this is where I think that the role of the UNCITRAL can be quite important. The UNCITRAL could write some documents, guidelines, whatever you want to call them, on how to organize witness evidence, catering for the consequential changes on the process that are necessary to compensate for the lack of a physical hearing. So not only accepting that or observing that a hearing can be, a testimony can be given also remotely, but also showing how this implies that the whole process has to change. For example, by permitting witness statements and assuming a higher degree of activity by the arbitral tribunal. Now, this is typically an area that is left to the arbitral tribunal's discretion, how to organize these things. And we can see it, for example, in the notes on the organization of the arbitral proceedings by the UNCITRAL. The UNCITRAL is not suggesting anything, is leaving to the arbitral tribunal to decide, or to the parties to agree on how to organize. However, given the necessity to give a push to some legal traditions, so to align the different approaches of the different traditions to the new needs that come about with the remote hearings. I think that it could be really useful to have some more some recommendations rather than simply some descriptions. And the instruments of soft law that we have, extremely useful that we have today, they don't seem for the moment to address specifically this question. So I would suggest as a possible topic for the UNCITRAL in the future to write some recommendations on how the whole process, the whole organization of the process and the active role of the arbitral tribunal can be impacted to cater for the lack of physical presence when the witnesses are making the deposition. So I will stop here. Thank you very much.
Thank you, Juditha, and thank you for highlighting the human element that has to be preserved in the arbitration process, which is a key aspect of due process as a whole. As is the tradition of Working Group 2, we have on the list of speakers, the last speaker is Mr. Michael Scheider. You have 6 minutes. We will be starting the roundtable discussions at about 12 o'clock. So if you can limit your presentations to 6 minutes, but I believe that you'll be talking about the treatment of evidence. And you made a very provocative statement about forgetting about e-discovery yesterday. So maybe you can also elaborate on that as well. Thank you.
Shortly. Thank you very much, Jay. Good evening. We're in Japan. And thank you very much to the organizers. As Jay said, the aspect, the center of my presentation is evidence in the context of technology and fair proceedings. In fact, in particular, the impact of technology. And evidence, the purpose of evidence is, main purpose is to help the tribunal understand the facts. And from that perspective, we'll have to look at the different aspects of evidence. I will not speak of testimony, witnesses, because that has been covered to a large extent. I will, with respect to witnesses, I will only say the present system we have is the worst you can think of. The witness presents a written statement where the lawyers write what they think the witness should say. The witness is then at the hearing and delivered to cross-examination, where the other lawyers are trying to make him say what they think. Rarely do you really hear what the witness himself or herself has to say about it. So I think that is a point we need to consider, and the point Juditha mentioned, the greater involvement by the tribunal is important. Now, to documents. They are probably in arbitration practice the most effective and the most important source of information about the facts, and the most often considered as the most reliable source of information. Now, the greatest technological development with respect to documents in the last 50 years was, you may be surprised, the photocopying machine. If you look what's happening in arbitration and compare how arbitration evidence is presented now compared to what happened 50 years ago, you will see how important the photocopying machine is, to what extent that impacted the way we deal with arbitration. I may add a reference to the word processor that is responsible for producing all these documents, but then you have the photocopying machine that makes vast amounts of copies. Jay asked me yesterday in the preparation, where is the problem of due process and fairness? And now The answer is just have a look at an M&A case or a big construction case. Each side has armies of lawyers, claims consultants, accountants, paralegal experts, and they all produce paper. And they produce vast amounts of paper, and then the paralegals photocopy it, and then they heap it on the tribunal in the submissions. Then you have a new set of all these documents in the hearing bundle. You have the PowerPoint. And all of this is organized C1, C2, C356, R1, R2, R578. And all of this is thrust on the tribunal. And then on the other hand, you have a sole arbitrator or 3 arbitrators who are just faced with this mountains of paper, and now understand how can these 3 arbitrators get an understanding of the facts. What documents do they see, especially when you look at them in the deliberations? In the hearing they may ask, but in the deliberations they're alone. And there's very little thought about this. Now here, we have a new development which may bring the change, and that is the digitalization. That is something we've heard a lot about. It is something that really may bring a change or a help in the manner in which we deal with documentary evidence. And that is something we will want to focus on. It facilitates the access to documents, the search of information in documents, and this is why I thought the explanation of Reka were interesting, not in order to promote e-discovery, which I think is a red herring in international arbitration, but in order to use these technologies in order to extract the right information. There are many things we heard about the possibilities and the risks of electronic documents. We have easier access, we have easier manipulation. Now, the real issue I see is the great amount of resistance. When I start an arbitration, even with big experienced law firms, the resistance you get when you start talking about a platform for the arbitration, about all these points that were raised, the resistance of the way how things were done is great. And to the interactive arbitrator that we were talking about, I wrote some time ago a paper on the uncertain future of the interactive arbitrator, precisely because these good ideas in practice receive little acceptance. So I think one of the things that UNCITRAL may have to concentrate on is how do these good ideas disseminated and are turned into practice. And I think that is my message. Good luck with all these nice ideas. Good luck on applying them in practice. Thank you.
Thank you, Michael. Before we start the roundtable discussions, I think there were a number of interesting questions in the chat and in the Q&A with regard to the different approaches in the civil law and the common law approaches, whether mediation can take over arbitration, whether the use of artificial intelligence in the decision-making is something that we need to take into considerations, the right of the parties to opt in and opt out of the use of technology, the financing of the different tools, including arbitrator intelligence. That was a question posed to Catherine. How to enforce online awards, and what the change would be with regards to confidentiality in the process. So these are some of those questions that we have seen in the Q&A, and I would ask the speakers if they want to answer any of them to do so in the roundtable discussions. Before we start the roundtable discussions, just so that everybody knows, the video recording, this is being recorded, and we'll try to make the video recordings available on the website. And all of the PowerPoints shared by the presenters will be also made available on the UNCITRAL website. So if you're looking for references, you'll see them on the UNCITRAL website. So to start our roundtable discussions, I'll give the floor to Anna, and I would also ask all of the speakers. I think we have 22 to turn their cameras on, and then I give the floor to Anna to kickstart the roundtable discussion.
Thank you very much, Jay, and thank you to all the speakers and the experts that have contributed to these 2 days. They were extremely interesting, very much focused, and very thought-provoking. That's the least I could say. We've heard a lot yesterday about the current projects that have been brought to UNCITRAL for evaluation, for exploration, and for further preparation. We've also taken stock of the impact of technology in arbitration and in mediation, and I'm very grateful that mediation was not forgotten, but it was fully part and parcel of these 2 days. There were very interesting points made, including today, this morning, about the need to preserve the fundamental values of arbitration, and particularly due process, fairness, party autonomy, and that this was particularly important when moving into the digital economy. What we've also heard, I think, times and again, is that the rules as they are actually flexible and broad and generic enough to allow or to cater for all these changes. What we see, however, is that there are important changes in practice, as Judita was mentioning, or maybe to be further promoted so that they turn into practice and that they are actually used more efficiently and can make arbitration proceedings more efficient, as we've heard from Michael. So what I think is really important, having heard all these points of view, is that we have this roundtable to really take away your recommendations to the UNCITRAL Commission, who will meet this summer, and to tell us what we can do. And we've already heard some very good suggestions as to there is a need for further developing soft law. There could be useful protocols that could be used by parties that they could refer to, and if coming from UNCITRAL, they would have this sort of universal value that would make them more acceptable. We've also heard a lot about all these sharing of good practices. And I think that one of the values of the project supported by Japan, and also of as exemplified by these 2 days together, is that there is a lot of practice to share out there, and that indeed kickstarted by or multiplied by COVID-19, but a lot of it was already there or could already have made it into mainstream. So all of this is, I think, is really very interesting. But as Jay mentioned in the opening this morning, we are a legislative body, so we are meant to, at least for the work that our working groups are doing, to aim at sticking as closely as we can to our mandate, which is harmonization, and which is contributing to the legislative development. Contributing to best practices is nice. Having a lot of good technical assistance that picks up exchanging practices is extremely useful. But that's not really the core of what we do. We do it because it's part of our promotional activities, but the core activities of UNCITRAL are legislative in nature. So I would like to simply give you this question now and say, how can these 2 days of what we've heard in these 2 days, how could this translate into legislative work? And I would say of the higher category, of course, we can make toolboxes. We've done that in the past, and we can continue to make good toolboxes. But if we can do something with a bit more legislative and harmonization content, it would make me as the Secretary of UNCITRAL much more happy. So with that, back to you and to your interventions, suggestions. We've already heard from Michael that there's still a long way before all these new technologies find their way into practice, actually. So I would suggest an even longer way before there is a need for harmonization. But all of you have had very great ideas and suggestions. So we are all there and all ears and eyes to listen and see you in this Q&A session, in this, roundtable discussion. And Jay, I leave it to you to moderate. Thank you very much.
Thank you, Anna. And your inputs would actually make my life easier as well, because I have to present all of these to the Commission as well. Now, we have 23 speakers. I see 23 faces on the screen, and we have exactly 20 minutes left. I would like to give the floor to those experts who spoke in today's sessions first, because I know that the day one speakers had their chance. I would like to ask you to limit your responses to 1 minute each, and then you can answer any of the questions that was just posed by Anna on what UNCITRAL should do in the future, or any of the questions that are posed in the chat. So unless you don't want the floor, I would like to give the floor to Andres first for 1 minute, please.
Thank you very much, Jay, for giving me the floor. What I did today is to give an update of where the working group is in expedited arbitration proceedings. The thing that I can say, and looking at the questions and everything that I heard in that regard, is that what I think, and speak about technology and dispute resolution, is that I think that the important thing is that I would like to stress, and I think we saw during the preparation of the expedited arbitration rules, is that expedited arbitration rules basically challenge us in order to really create the balance between efficiency on one hand and expeditiousness and fairness. And this is what I say, that this is probably the future, because really somehow you get to the bone, to really what it is, the minimum that you have to preserve in order to have, the core principles of arbitration in a set of rules. So these rules were also created, and with this I would like to finish, looking at tradition, because of course we preserve the core principle of arbitration, but also looking into the future, which is a good expression of this the use of technological means that it was included in the provision, and others that people will hear soon when we will be able, to speak more broadly about the rules. But I think somehow what I heard, everything that I heard today, and I have to say, is encompassed in the work that we did somehow, which is, use the core principles, but also look into the future. And at the end, this is arbitration. It's not something different. It's international arbitration, and therefore, we have to bear in mind that this is the ultimate goal, and therefore, this balance is essential. Again, modernization, but also preserving what has been proven to be good in terms of dispute resolution. Thank you very much.
Thank you, Andres. Yoshimi, from a practitioner's perspective, maybe some inputs?
Yes, thank you very much. Jay, you asked us at the outset, which institution, which party should play the role in enhancing the use of digital technology in settlement dispute. And I think, each institution, including UNCITRAL, has a separate, unique role. Like, arbitration institution perhaps played an important role in setting up the technological platform, because it requires, substantial investment, money involved. And only institution having enough money can provide that kind of services or establish, platform. Talking about, clients and law firms, perhaps, they should play the role in establish good software, facilitating the quality of legal services and improve efficiencies of services and make the life of junior associates easier. We call it restoration of humanity within the law firm. And lastly, I think, yeah, Ada suggested, UNCITRAL is focused on law, not the soft law, the actual hard law. But it takes a while before the law will be to create the consensus among the member state of UNCITRAL to come up with the agreed form of law. So in the meantime, I think the UNCITRAL can do a lot of things, including soft law, providing guidance as to how technology can be developed in a fair manner, and how to address the disparity between those who have technology, those who do not have technologies. And UNCITRAL is the great platform because it's a representative of all different countries with different backgrounds. So I do encourage UNCITRAL to come up with good protocol to address those kind of disparity.
Thank you, Yoshimi. Rekha, 60 seconds.
To take the question that you posed, Jay, to us at the end when we finished panel 1, I do think the parties will drive the optionality. they will give the choices, but in truth, noting party autonomy, it will be the institutions. They've always been the leaders globally, the ones who have assessed protocols, who have given legitimacy to the process. And in truth, that's often through the different institutions represented even here on these screens that UNCITRAL takes stock of what has worked, what hasn't, what has been used, what hasn't. And I think we're going to see that yet again. Digitization is here to stay. So is renovation, but we're learning in real time all of the time what's working. So I think there's a lot still training to be done, but a lot more we're going to learn still.
Thank you, Rekha. Liz, automation is here to stay. Any views?
It's most certainly is, and I think we have so much more we can do with it. And I want to plus one on what Rekha was saying, that I also think spend quite a lot of time thinking about who is driving change here. And I think in terms of who sits on both incentive and money, the parties, or at least the councils, usually have bigger not visions, but maybe wallets, because it's usually can be really big law firms and they have the ability to build quite a lot of big technology, whereas the institutions generally have had less so. But I agree with you as well that it needs to be the institutions, I think, that takes on this role. And that's a challenge for us as a community, where all of the institutions currently are stepping up. And as Yoshimi mentioned as well, that it's the bigger institutions that maybe have the chance to do this, because it does require quite a lot of investment. So it's going to be interesting to see what that will mean for the competitive landscapes of the institutions, and maybe to some extent we should collaborate even more here to make sure that it's not just the biggest ones that survive, because I think there's a need for several of us around and not just us big ones. So in that, I think the reality is parties are pushing more. The ideal is that institution comes even stronger. And I think to answer one of the questions that was posted in the chat, how do we make sure that you don't have unilateral interests kind of corrupting their overall goal? I think that's where UNCITRAL comes in as well, to make sure that we have the guardians of the process in the room as well. So that's kind of how I see the actors in this play.
Thank you, Liz. Now we have two Kevins, but this time I'll go with Kevin Kim first, because I gave the floor to Kevin Nash first last time. Kevin?
Thanks, Jay. Maybe I'll start with one of the questions in the Q&A, this idea of whether you can opt into virtual hearings. I think that what's going to happen there is that parties are going to vote with their drafting pens. So you look at the relative set of institutional rules. Do you want to fortify it even more, maybe 5 years before the dispute, to say that the hearing will be conducted remotely? That's why it's probably better to leave it at the discretion of the tribunal. And it also raises the question of whether institutions leading the way, whether there should be convergence or divergence. Should all the institutions be offering the same technological protocol, or should parties be able to choose that this institution, I have the option to do this other institution, I have the option to do this? From an UNCITRAL standpoint, I recognize that it is difficult to codify anything on this because it's so rapidly evolving. How do you future-proof this? But I think that what UNCITRAL is doing already, particularly in Working Group 2, is validating a lot of the procedures that institutions already have. So the fact that UNCITRAL has now, or almost, a fast-track procedure, every other institution that has an expedited procedure, it just legitimizes it even more. So I think that the work that's being done already by UNCITRAL is very helpful, because I think the parties more and more are going to start using these special procedures that already existed, but are even more important now during COVID-19.
Thank you, Kevin. I think Kevin Nash was faster than Kevin Kim with the microphone, but you have the floor, Kevin.
Okay, the other Kevin actually covers wonderfully about what I wanted to say, but I want to add one thing. What I want to propose to UNCITRAL is that we have issue of the, I will call, soft venue. We already sorted out the issue of hard copy versus soft copy, but now we are living in a soft venue in international arbitration. We have same issue. I actually recently have a lot of questions about their positions or witness examination using video in court hearings, but we have same issues where we are, doing all these things virtually. So this is a legal issue. Somebody have to establish the legal principle where we are and how we interpret legally we are in a virtual hearing. This is a very important issue. This is related to how much we can treat virtual hearing as equivalent of in-person hearing, and under what condition, and what law shall apply. So I will propose UNCITRAL organize some group, think about such a legal issue, and have some answer, if there is any answer. I'll say. Thank you very much.
This is a real question. Actually, we have had our working groups, which were supposed to be taking in New York, but this was done in virtual fashions with hybrid in-person participation in Vienna. Whether these meetings are being held in New York and Vienna is a real question to us as well. So it is something that we need to look into as well. Catherine, you had a number of questions in the chat, but if you want to address those or any of the other questions in 60 seconds, please.
Okay, let me try my best. First of all, very smart questions in the chat. With regard to an artificial intelligent arbitrator, I still think that's science fiction, not real. But one of the things I think even the imagination about that suggests is that we need to, as we implement technology, not only talk about the fairness that's been discussed in this program, but also I think the integrity with which technology has been adopted, which leads to another question that was in the chat: how is arbitrator intelligence funded? So we started out as a research project, then we were a nonprofit, which basically meant we had no money to kind of make ourselves work. We've become a legal tech startup, which means we have outside investors. In the area of integrity, we do not accept investments from law firms or third-party funders, but our individual investors are sometimes lawyers. We're actually still trying to raise money, so if you're interested in being an investor, follow up with me later. And I think that might be my 60 seconds there.
We'll now move on to the speakers from session 2. Jerry, any comments? I think Jerry might have left. Mr. Dogauchi.
Well, thank you. I think arbitrators tend to follow the court practice in the jurisdiction where he or she studied law. So in order to unify the way of arbitration, we have to unify the court practice in this globe. But it is, I think, not impossible, but very, very difficult for the lawyers to follow one practice. And as I am a professor teaching conflict of laws, so I like conflict and the difference of laws and the difference would produce innovation in the future. So I expect the good result of the UNCITRAL trial to make a rule on the arbitration. Thank you.
Thank you, Mr. Dogauchi. I think your point and Kevin Nash's point about different approaches actually being, it actually promoting arbitration as a whole is something that we also need to look into as well. Paulus?
Thank you. Well, I would like to just shortly echo your remark on further alternative dispute resolution. There's just one thing to mention: the permeability of arbitration proceedings regarding those alternative dispute resolutions, which is also essential for early conflict settlement. But talking about convergence and harmonization as one of the tasks of UNCITRAL, yes, the idea of early conflict settlement as an element of cross-fertilization of the two worlds and not to deepen the divide of Anglo-American approach and civil law approach would be an aim, and to that end to raise awareness regarding this tool as another means and option for parties of arbitration and other alternative dispute resolution. Thank you.
Thank you, Nusha.
Thank you very much. Yeah, the question about harmonization and contributing to the legislative procedure and framework is indeed a difficult one, but I think we have to, with the example, for example, of the Austrian Supreme Court decision, also look at the courts and how they, in fact, interpret already the existing law that there is, that one allowing for remote hearings in taking place in arbitrations. As Giacomo has said, there is still a divide in general from jurisdiction to jurisdiction, but in general, I think we have to look at what has happened in the past before 2020. Many times, actually, the parties, the cases that were more maybe the driving force and innovation, the council obviously as well. And in 2020, something miraculous happened, that the institutions immediately changed with the parties, with the council, with the proceedings, with the cases. And I think that was really an amazing development, which we should continue seeing. And in terms of harmonization, I just want to remind everyone, as you know, but the wording is quite interesting. So you will know in 2006, UNCITRAL gave a recommendation about the interpretation of Article 2, Paragraph 2, and Article 7, Paragraph 1 of the New York Convention. And of course, the text was in light of the widening use of electronic commerce, amongst others, this recommendation was given. So I think UNCITRAL is in a very good position to give a recommendation in the use of technology, now a bit broader than only emails, whether that also constitutes in writing or not, under Article 2.2. But it is something I think that is already in the making. If it is difficult to get the all states together, I think UNCITRAL can, on this point at least, I hope, find a quick solution, because I understand that all states are affected the same way, and therefore, at least in technology and the broader use of technology would then also avoid all the cases ending up before the courts, where due process is supposed to be violated, but the courts then very often decide, no, it was a normal, ordinary process of the tribunal's powers to conduct the proceedings as such.
Thank you, Nisha. We're running out of we're running a little bit late, but Giacomo, maybe to make sure that 60 seconds.
Sure, thank you very much. I just would like to stress the relevance of the model law in our projects. Much of the arguments submitted by the reports focus on either the interpretation of Article 24.1, and we said before the how the expression oral may change in different jurisdictions. This has been a very fascinating, in my opinion, study. how an event can shed light on a single word, oral, and now we collected a lot of literature from multiple countries interpreting just one word and how the single word interacts with the entire procedural rule system of that jurisdiction. And obviously, as I said before, the relevance of Articles 18 and 19 and the different rights of the due process, the balancing activity we described before. So again, the model law was really at the center of our project.
Thank you, Giuditta, and then followed by Michael. 60 seconds each.
Thank you. I'm speaking, yes. I actually would like to give my full support to what Nusha was saying, because I was also thinking that there are very clear parallels with the interpretation or recommendation on the interpretation of Article 2 of the New York Convention that was done some years ago. And this would also be a way of this would be catering for the possibility that we have already today, as Giacomo was showing. Today there are a lot of jurisdictions who interpret the model law so that oral hearing also means remote hearing. So changing the words of the UNCITRAL model law would create difficulties with respect to those jurisdictions who already are interpreting it like that. And therefore the authentic interpretation by the UNCITRAL of what oral meaning actually means would be rendering life easier. On the other hand, it would require a lot of tuning and description of impacts on the process and so on. So it would have to be accompanied by a quite detailed explanatory memorandum, probably. Thank you.
Thank you, and I'll give the floor to Michael. For those of the speakers who are speaking on day one, if you have any urgent need to speak, please shake your hand or raise your hand so that I know, and then I'll give you the floor following Michael. Michael, you have the floor.
Yeah, the remarkable result of these 2 days was to see that we are in a period of blooming ideas, fermentation, and great blooming of new ideas. So what is important now is to preserve diversity, and diversity in ideas and in approaches, not just between civil and common law, but even within the civil law world. The Germans and the French are very different in doing things. So one of the main functions of UNCITRAL is precisely the diversity of throughout the world. So one of the main functions or contributions of UNCITRAL in this period would be to see to it, like we've done today, to preserve the diversity. And I would say for UNCITRAL, let the wine ferment, decant, before you bottle it into legislation. So the role of UNCITRAL in this process rather is an observer and an assistant in preserving diversity so that the process is not hijacked by the big law firms or the big arbitration institutions, but we preserve the diversity. Thank you.
Thank you for the nice comments. I think that was, we need to also be rulemaking, but also winemaking as well. I know that we have 4 hands raised up from the speakers from day one. I would ask that you to limit your interventions to 1 minute, because I think we did start a little bit late, but we would like to end at 12:40 Vienna time. I see Itai, please.
Yes, thank you, Jay. So Cedric spoke for me yesterday. I'll just briefly maybe respond to what Anna asked. I think that both the proposal by Japan and proposal by Israel on high-tech disputes and the stock taking that we witnessed these 2 days really show how these 2 proposals complement each other. Our vision is for work in the working group on a norm or some sort of soft law instrument which parties can refer to, which will basically build upon what we heard in these past 2 days. And in response to the doubts that were voiced about adaptation and implementation of practical and new ideas, we think that the high-tech industry is ideally situated for rapid adaptation and flexibility. So it might be that UNCITRAL can offer, hopefully in 1 year or 2 years time after 4 or 5 meetings by the working groups, a package that would have this focus on high-tech, but could also be used for general arbitration. And I think, and we think at least, that the high-tech industry could lead the way in its adaptation and flexibility to other industries to show how these platforms can be optimally used. Thank you.
Thank you, Itai. Stefano, you have the floor.
Thank you, Jay. I will take less than 1 minute also because after 15 very good proposals and intervention, it's very difficult to say something original. So I would endorse anything that has been said, very wise advices. I would simply add one issue that I don't know whether it can be covered, can be touched by UNCITRAL, but at least we experience is the enforceability of arbitral award according to the New York Convention, not signed in hard copies. That has been an issue, and I think it will be an issue. Last year, during the lockdown, some arbitrators could not materially, physically sign, print and sign awards, and the issue was whether those awards were enforceable according to the New York Convention. Again, of course, we all know that nobody wants to touch the New York Convention because it's so far so good. Absolutely not. Then I fully agree, but that's an issue, and I don't know how to deal with it. But that's I think an issue that would be very good to talk about. Thank you, Jay. Thank you, Anna.
Thank you, Stefano. I think that was also mentioned in the chat, and we did also receive a proposal from an institutions on the online awards as well. Next, I have Yoshi.
Thank you, Jay. Yeah, Yoshihiro, not the Yoshimi, but we have two Yoshis here. So responding to the Anna's point, and so which institution or who should take a role for the, and that getting back to the first date, the high-tech dispute resolutions protocol or guideline or something. My idea, concrete idea, is the JCAA, Japan Commercial Arbitration Association, which is led by Professor Dogauchi, and JIMC, Japan International Mediation Center, which involves the James Claxton's initiative. So those two institutions can take a huge role, including the interactive arbitration rule, which today Professor Dogauchi explained. So those three reasons. So first one is the made of nice combination. Then second, harmonization of the civil law aspects and the common law aspects procedure. And then third, especially for high-tech protocol or guidelines, the facilitative aspects and the experts evaluative aspects should be significant. So I strongly recommend the JCAA and the Japan International Mediation Center, who can take a strong role as the representative of the Japan side. Of course, we need support of the Ministry of Justice, which is led by Takashi, of course. So with the strong support by the Japanese government, so those two institutions can take a role. Thank you.
Thank you. Ms. Kunfan, I think you had your hand up, but it's now lowered. Would you like the floor, Ms. Kunfan?
Thank you, Jay. Yeah, so I might just very briefly, a brief remark in light of the question also with regard to the use of AI. So I think the technology, of course, we've discussed the digital economy. Technology certainly pushed for the development of dispute resolution, but it can be double-edged sword. So I just want to raise the point that we should probably also avoid this AI or technology utopian and to realize the limitations of AIs in terms of like value judgment or human sentiments, and there's still this human elements in dispute resolution. So some issues that we might consider is developing some ethical standards with respect to the use of AI in the delivery of justice in arbitration or mediation procedures, legal regulation. Some research already been done with respect to regulation of medical malpractice when there's an error in the AI in the medical practice. I think similar question might be asked also about accountability of AI in assisting the delivery of justice. And finally, the theoretical question we might consider is if AI can be used to resolve disputes, would the very concept of justice even change over time? Thank you.
Thank you. I think with that, we've heard from all of the speakers. We have gone a little bit over time, but I think what the discussion today shows of yesterday and today shows that there is the need for stock taking. We need to do a lot more stock taking in order for us to build a basis to deliver rules that actually works in practice. We have received your recommendations. We'll take note of them. But in doing, I think that we need to not only balance efficiency and due process, but we need to do a lot of other balancing as well. We need to balance between divergence and convergence. We also need to diverse the different interests of the parties and the different roles of different parties in the arbitration process. So I think that's what we can gain from here. We hope to present this to the Commission this year, and then maybe the Commission will be, definitely the Commission will be more, be informed when it makes decisions on what is to be mandated to Working Group 2. Before closing, I would like to give the floor to Takashi to give the closing words. Unless Anna, would you like to? No? Okay, Takashi, you have the floor.
Okay, thanks, Jay. I could, in light of all the discussions we had, I could go on with a long diplomatic thank you statement, but I would refrain from doing that. And I would just simply thank all the speakers, the guests, for the 2 days, consecutive days, discussions. They were all thought-provoking and also insightful. And finally, and not least, I would like to express my sincere appreciation and gratitude to Ms. Anna Joubin-Britt and her team for working together to make this happen. But before I say my final words, and I'd just like you to allow me to point out to a good colleague of ours, Ms. Eun-Young Nam, a legal expert of UNCITRAL, who has helping us out greatly in the operation of this event. And I would like to kindly invite Eun to turn on her camera. I know it's a little bit kind of pressurized, putting some pressure, time pressure on her, but to say a few words before we close.
Thank you very much, Takashi, for your kind word, and I really appreciate it. It was really great honor to help organizing this event. Thank you very much for our colleagues and all the speakers. Thank you very much.
And many thanks again to you, and with that, I would like to close this workshop. Thank you so much.
Thank you, everybody, and see you again soon.